Reno Tirikatan.
Thank you, Mr. Chair. I'm pleased to speak in opposition to this bill at this committee stage, sir. But I do so as a proud member of the Labour Party, which is the original party for free trade. But this bill, sir, is not a trade deal. It's not. It's not a trade deal, sir, because this TPPA, what does it do? It works in favour of the American multinational pharmaceutical companies. It works in favour of Silicon Valley technology companies. It works in favour of Japanese manufacturers. But it doesn't work for New Zealanders. Sure, there are benefits that we may have on the primary sector that we're seeing, but we haven't had a full, proper analysis to really have a full assessment of the impacts of this agreement to New Zealanders as a whole, and that's why we are opposing it, sir. Sure, I mean, if we look at it, protected dairy markets are still intact, largely, as a result of this, and yet it was lauded at the time that this will be a breakthrough deal for our dairy industry, our world-leading dairy industry. Well, not so much the case. Not so much the case. But, sir, I want to really shift the focus of my contribution at this time to look at the impacts for Māori on the TPPA, and in particular, that groundbreaking Waitangi Tribunal report and claim that was Y262, Ko Aotearoa tēnei. Now, that was a groundbreaking claim, sir, all about the place of Māori culture and identity and traditional knowledge and its recognition within New Zealand laws. You know, it covered big questions about who controls traditional knowledge, who controls artistic and cultural works. For instance, our haka, our waiata, our culture. Who controls the environment that created our culture and that emerged from the natural environment? And those are big issues to Māoridom, sir, big issues. And it took 20 years from 1991, when the original claim was lodged, through to 2011, 20 years for the Waitangi Tribunal to issue its landmark report, a whole-of-government report, first of its kind, where it looked into and made strong recommendations on this, in this whole area. And this is the real concern that Māoridom have, sir, is that by signing away this TPPA, we're losing control, even more control, over our taonga. And this is what it gets back to, our taonga, that is there in the treaty that was signed. And that was the basis of Y262. And the fear from Māoridom, sir, is that we will lose this, even more control of this, by signing away our rights in this TPPA. And I'd like to give an example of that, sir. Because within the TPPA, there is an obligation. There is an obligation on New Zealand under Annex 18A to Article 18.7.2 to either adopt the International Convention for the Protection of New Varieties of Plants or legislate for our own rights system that gives effect to that convention. Now, sir, that obligation could be very problematic to Māori, and yet we are getting no clear signal from the government whatsoever as to what their plans are, as to how we will give expression to that. The government needs to be more upfront, and that's what Māori are concerned about. They need to be more upfront so we know exactly what that entails. And this goes to the point, sir, of ratification. Why, sir, is this government racing, wanting to dive headfirst into ratification of this agreement when these very important side issues have not been cleared off? The government hasn't been upfront with iwi Māori katoa as to what it intends to do around how we implement our obligation to this. Now, sir, I note that there is the Treaty of Waitangi exception that is contained, and it's the standard boilerplate provision that's in there. But, sir, again, words can mean a lot of things, but these are obligations that we apply. And I would just like to give the example, sir. Sir, Mr. Chair, thank you, Mr. Chair. What say a Mexican cigarette manufacturer wants to put my ancestors' tā moko on his cigarette, on that company's cigarette packets? What's to stop them trying to make money off my tupuna's and off our collective cultural IP? And what will our government do if our government tries to move in, to step in to try and, what will our government do to try and protect our IP on that situation? How will the Treaty of Waitangi exemption apply in that scenario? Will we be hauled before some secretive tribunal, international tribunal, whereby another foreign state can lay claim against us for them being denied the ability to make money off our IP? I mean, these are serious questions that are of deep concern to Māori, and the government hasn't made the case. It hasn't made a clear case, and it hasn't been upfront as to how it will protect our cultural IP on these matters, when it has already signed away its obligation to ratify and implement, or indeed put in place its own regime. And I certainly hope that the government will be doing something that is accommodating of Māori concerns. In fact, that aligns with its Treaty of Waitangi obligations. But again, sir, we have heard nothing from this government on these matters. Complete silence. Sure, they might be buying a little bit of time to try and implement these obligations that are imposed on our government now that they've signed away and are wanting to ratify this agreement. But again, sir, it is of deep concern to Māori, to ngā iwi katoa, and I think it should be of deep concern to our whole country. We don't know the impacts that this will have on our cultural IP, and that Y262 claim, sir, is still sitting with this government. They've done nothing on it. They've been sitting on it for close to 5 years, and in the meantime, they've been rushing aside, trying to go behind secret doors, in complete secrecy, to ram through this deal when that Waitangi Tribunal decision, recommendation and report has just been sitting there, and iwi katoa are waiting. We're still waiting. We want a response, and we are deeply concerned, sir, at what this government will be doing and the impacts that it will have. Because as I've said before, sir, Māori are very well aware about signing things when things can go very, very wrong. We're all too aware of loss of our sovereignty, of losing what we think we have when we are a piece of paper is put in front of us. And so, sir, that is why Māori are very concerned about the TPPA. Sure, there might be other positive parts to it, and I do support those. Anyone wants to support things which will help our primary sectors, our productive sectors. But, sir, we need to have the full picture as to what the implications are on copyright, on IP, on cultural IP, especially in light of the Y262 report. And I was speaking to the daughter of one of the original claimants over the weekend, and they are deeply concerned, sir, that the government has done nothing around Y262, and yet they are rushing with all the gusto that they can muster to ratify this deal, which we know, sir, is a redundant exercise because we don't know what's going to be happening tomorrow or with the US elections. So why the rush? Why the rush? The agreement won't be coming into force until a couple of years from now. That's provided that all the countries who are party ratify it. And that is far from a certainty, sir. Far from a certainty. So we shouldn't be rushing this, sir. We shouldn't be rushing this. There are far too many very important issues to iwi Māori, sir. And, if foreshore seabird was a lesson for Labour, I think Y262, TPPA should be and IP and Māori cultural IP rights should be of very concern to this government. And so that's why I deeply oppose this bill, sir. Kia ora.